So nobody's family is perfect. Everyone has had some type of family problem or even major family dispute. And I mean, it happens, right? But at the end of the day, if the police are called to a family dispute, whether it's a dispute with a brother, sister, cousin, extended family member, mother-in-law, father-in-law, brother or sister-in-law, or a partner or a significant other, understand that once the police come to a dispute involving a family, it becomes a domestic violence call or a domestic violence dispute. And if you are ever arrested in relation to a domestic violence dispute, there are several things that you're going to need to know. The first thing is that once the police are called to any kind of domestic violence dispute, and I've seen this in just about every jurisdiction, they're required to take someone into custody. They're required to arrest someone. And that's usually if a crime has occurred or a crime has been committed. So for instance, if it's something as minimal as threats, like, if you cheat on me again, I'm gonna slit your throat or something. That's severe, but let's say you say something like that. That is a threat. And if it's in connection to someone who is a partner or a significant other, then unfortunately that's a crime and the police are required to take that person into custody, whether or not you actually intended to carry out that threat. Similarly with, actual physical fight. If there is a physical dispute in a physical fight, certainly at least one person is likely gonna have to go to jail, potentially both people if it's a mutual battle. So understand that typically there's no way around it. If you want the police to come to settle a dispute with the family, understand that if somebody tells the police exactly what happened and there's anything that's even remotely related to a crime, the police by law usually will have to take you or whoever's at fault into custody, and that person will have to be arrested, whether or not the person who called 911 wants you to be arrested. So there's usually no discretion once the police arrive. Now, the second thing that you need to know is that if you are arrested in relation to a domestic violence dispute, then you're obviously going to have to go to the police station, get a mugshot, get a fingerprint, and get booked through the police system. So now you're likely going to have an arrest record, whether or not it moves forward formally in court. Sometimes in these situations, maybe a prosecutor sees the offense and they see it's just really small or minimal, and they may decide, you know what, we're not going to pursue this. But ultimately, if you are arrested, you're going to have an arrest record, you're going to have a mugshot, you're going to have a fingerprint in the police database, and you're usually going to be assigned some type of, arrest number or number associated with your incarceration. And that's something that you may have to think about later, either expunging or sealing, especially if it could affect your job or career or your future. So the second thing is you're going to have to get fingerprinted, mugshot, you're going to get booked, and you're likely going to have to incur some type of criminal arrest record. The third thing that you need to know is related to the charges. Now, typically, there are usually two major types of charges. There's a misdemeanor, which are low-level offenses, and then there are felonies as well. Depending on the severity of the incident involved, you can get charged with a misdemeanor or felony. So for instance, if somebody, let's say there was a small push or a shove, then that could be a misdemeanor simple assault. Let's say someone is assaulted to the point that they have major bruises. It's debatable whether that could be a misdemeanor or felony. Usually if you have to go to the hospital or you need to be under a doctor's care, then that could be something that's considered a little bit heightened and more of an aggravated assault as opposed to a simple assault. So understand that depending on the severity of what's involved, you can get charged with a misdemeanor or a felony. Even if nobody is injured, if there is a severe enough threat, like, I'm going to burn down this house, that could be attempted arson, right? If there's a match and there's a lighter nearby, that could be attempted arson, and that's certainly a felony, even if you didn't actually carry out that threat or really didn't intend to carry out the threat. A threat is a threat. And so understand that the courts, the police, they take domestic violence incidents seriously because typically studies and statistics show that these are incidents that are likely to happen again. Most people who call the police for domestic violence incidents will call again. And so no judge wants to be on the hook for letting someone go if they're involved in a domestic violence incident. And so they will take setting bail and the whole entire process very seriously. So be careful of what happens during the dispute. And if it's a threat, whether you intend to carry out what was said certainly matters, especially in a domestic violence context. So the fourth thing that you need to understand is that if there are any weapons involved, that could usually be a felony. So for instance, if you pick up a knife in the midst of a domestic violence dispute or a fight, then that could be something that is as serious as assault with a dangerous weapon. That's a charge here in DC. In other jurisdictions, it could be aggravated assault while armed. And you never want a domestic violence offense coupled with a weapon. Usually that really heightens the circumstances. And because let's say there's an intimate partner or family member involved, judges are often going to take that seriously, especially when deciding bail or deciding if they want the person to be released or not. So never pick up a weapon in the midst of a domestic violence dispute. Certainly you want to protect yourself. And if you have to call the police, hey, it is what it is. But understand that if a weapon is involved or somebody is holding a weapon or is near a weapon, that is going to absolutely be taken very seriously. The fifth thing that you need to understand is that if you are charged with a domestic violence offense, you usually will not be able to possess any guns. So for instance, if you have a concealed carry permit or you have a firearm that's registered, you may have to relinquish ownership of those firearms until the case and the dispute is over. If you're convicted of a domestic violence offense, you may have to permanently release those firearms or turn it over to the police. So usually while you are charged with a domestic violence offense, for the most part, you may not be able to keep your firearms in your possession. You may have to at least temporarily turn it over to the police. The final thing that you need to know if you're ever charged with a domestic violence offense is that there is often going to be some type of stay away order. So this is really important, especially for people who are charged with a domestic violence offense and it's someone that you live with, or it's a spouse or a partner, boyfriend, girlfriend, or otherwise. If you live with that person, for the most part, I typically see judges issue a stay away order. And that means that you may have to pack up your belongings and temporarily leave your own residence while the case is pending. I usually see this, especially with maybe the person who's the breadwinner. You may have to leave your own residence that you pay the rent or the mortgage for, even though the other person that is involved in the domestic violence dispute is not on the mortgage or the lease. So keep that in mind, that sometimes you may have to stay with a family member, mom or dad or brother, sister, or cousin or something, even though you have a separate mortgage or rent that you're paying. And usually the judge is not going to kick your partner out or your spouse out of the residence. They're going to say, well, that's a separate landlord-tenant situation. If you want to kick them out, you're going to have to go through landlord-tenant court. So be aware of any stay-away orders. Usually, in cases where I have clients that are charged with a domestic violence offense and there's a stay-away order, I ask the judge to perhaps modify it. And in DC, we have something called a no hats order. That stands for no harassing, assaulting, threatening, or stalking behavior. That perhaps if both can peacefully live in the same home and there's no threat of any further physical dispute, that perhaps maybe they can stay on different rooms, but they cannot commit any new crimes or cannot harass or assault the other person while the case is pending. Usually that allows you to stay in your own residence, but at the same time, you're still under court order to not engage in any further behavior. So something really, really important to be aware of, because that can be financially taxing if you have to continue paying your mortgage while living elsewhere. So I hope that's helpful to you. If you have any other questions about domestic violence offenses, feel free to comment them down below and I'm happy to answer any questions that you have. And if you have any further questions that you want to chat with me, you can contact me on my website, mydclaw.com, and I'm always happy to chat with you further. As always, stay safe, take care, and I'll see you soon.